Good afternoon, everyone. Welcome to the Lackawanna City Council special meeting of Thursday, September 4th. For the special meeting, we don't have any caucus, so I'd like to formally call this meeting to order and start with the Pledge of Allegiance, please.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please.
Maflahe has been excused. Anderson?
Here.
Moretti?
Here.
Sirdike?
Here.
Morano has been excused. Law Department?
Here.
All right, we're here today for a appeal request, FOIL. I will turn it over to our city attorney right now to explain what we're up here for.
Yep, so thank you. Today, it's my understanding is an appeal of a response to a FOIL request, which was served by Manamusin on July 31st, 2025. I can provide the council with whatever additional information they may need. I'm not sure if the council is inclined to have Mr. Musin speak or whatever the council would decide, or if you'd like me to state the city's position first.
Yeah, would you like to speak or no?
Yeah, I would like to speak, but I would rather hear the city's position first. That's all.
I mean, that's up to the council.
No, you're here, you could speak.
I applied for it. I'm being denied. There's a special meeting because of this. I'd like to hear why it was denied before I respond to it.
What do you think?
I mean, the way that the council meetings are conducted is within the complete control of the council, and I believe we had one other FOIL appeal wherein you spoke first, and that was how it was handled at that time.
Yes,
I
you
don't
did.
believe I spoke first at that time. I did not. I actually came late and spoke.
Would you like to speak or not?
Yeah, I'll speak. I'll definitely speak. Since the
Yeah,
attorney
3
is,
minutes, please.
How many minutes?
3.
3 minutes? I don't need that much. Hello and good afternoon. This special meeting should have never been called in the first place. The only reason why we're here today is because the city attorney denied a FOIA request. That clearly falls under New York law. That denial was not just wrong, it was unlawful. Here is what I asked for: the names and titles of the people who decided to read the June 25th email allowed at the Planning and Development Board meeting. An email that falsely branded me as a child abuser, despite there being no evidence, no history, and no record of any abuse ever existing. The names of those who decided to withhold that email from me, the applicant, and the board members in advance, and the council. And the names of those who decided to keep it from the agenda. Those are government decisions. And under Public Officers Law, Section 86(4), records mean any information kept, held, filed, produced, or reproduced by or for a public body. That definition covers notes, memos, directives, emails, and yes, the record of who made those decisions and why. To say this request is outside the scope of FOIL is not a mistake. It is a deliberate attempt to shield officials from accountability. Let's be clear, either the record exists or they don't. If they exist, they must be disclosed. If they don't exist, then the council has an even bigger problem, because it means city officials made serious defamatory decisions off the record, leaving no accountability trail at all. That is either concealment or negligence. Either way, it's unacceptable. And now, instead of complying with the law, we are here in daytime special meetings, wasting taxpayer money, pulling staff from their work, and forcing residents to attend during business hours. All because the city attorney refuses to follow FOIL. This is not transparency, it's obstruction. And this is not the first time. The city attorney has a pattern of blanket denials. She has abused attorney-client privilege even claiming it over conversations
All right,
she was
all
not
right.
involved in, using it as the shield
Out of
to
order.
protect corruption.
You're out of
This
order.
is not a privilege, that is a fraudulent misuse of office. You said I have 3
We
minutes.
don't
Your
have,
3 minutes.
yeah, well, take it easy.
What's my 3 minutes?
He timed you.
10 seconds.
So I reclaim, I still had 10 seconds and you're stopping me. Reclaim my
So
time.
that's because of your attitude of degrading somebody.
I am not
She had-
degrading
wait a minute.
nobody. This is the evidence right here. The evidence is in
Alright.
front of each and one of you. If you want a packet, I definitely can
Hey, you
give
can
you
think
a
and,
packet.
you can think and say anything you want to me, but to degrade her in front of the public and us is uncalled for.
I didn't degrade anybody.
didn't.
I told you
You're
what
out of
her
order.
actions
Both of
was.
you.
And her actions is unlawful.
Alright.
Under FOIL,
Calm down.
she broke the law. You need to calm
No,
down.
you need to
I've
calm
been
down.
standing up and I've been talking. You're the one that got up. You're the one that is acting outrageous.
Am I?
I had 3 minutes and I was interrupted.
I'll tell you what, after here, we'll talk about the 3 minutes when we get out there, okay? How about that?
What do you mean we'll talk about it?
We'll talk
We're
out
at
there,
a
not
special
in-
meeting to
not in
talk
front
about
of
it.
us.
We're here at a special meeting to talk about it.
If I could interject, I think Mr. Moosen's point is that he had 10 seconds left before he was interrupted.
I was interrupted.
Excuse me,
Okay, go
Mr.
ahead.
Moosen, if I could speak. I think, Mr. Moosen, correct me if I'm wrong, if you wanted to speak about what's in the packet, the agenda for today is to talk about your FOIL appeal from your July 31 FOIL request. I believe the information in the packet relates to a prior FOIL request, which is not covered by what the council is considering today. That is the subject of what Judge Kloyakovo is presiding over, right, currently with respect to your current Article 78 proceeding. So that's really outside the scope of the agenda for today.
Can I
The agenda,
respond?
one moment, please. The agenda for today is for the July 31 FOIL request. And if you'd like to, it would be my position if Mr. Moosen would like 10 seconds back to speak about that.
Yes.
That's fine. But I
Yes.
think to the extent you want to talk about what's in the packet, that really is not before the council today because that is before the court.
The pattern of how you respond to FOIA requests is absolutely relevant to this FOIA request. It is 100% relevant because it shows a pattern of obstruction and how you keep public records. These records, they do not belong to you, they belong to the people. They belong to the people. And you are withholding these records unlawfully to protect corruption.
So I think Mr. Moosen's had his 10 seconds, so may I
Yeah,
respond?
more than enough.
Okay.
Sure.
As an initial matter, I'll just say for the record that the law department completely denies any wrongdoing, obstruction, non-transparency as alleged by Mr. Moosen. As the council is aware, there is a current Article 78 proceeding before Supreme Court. It's before Judge Kloyakovo that relates to and encompasses some of the issues that Mr. Moosen has brought up this afternoon. Putting all of that aside, this afternoon we are here to talk about his appeal from what he phrases as a denial of his July 31st FOIL request. The council has that response in front of them. As Mr. Moosen noted, there are 2 numbered items that are requested in that FOIL request. The first are the names and titles of all individuals who made the decision to read the June 25th, 2025 email aloud at the Planning and Development Board meeting, decided not to share the email with board members or the applicant in advance, and concluded the matter should not be placed on the meeting agenda. The second item is for any written rationale, memos, directives, meeting notes, etc., relating to the decision to read the email aloud. In response, I'll take the second item first because it's very straightforward. The city's response is that there are no responsive records, so that's not a denial of a FOIL request. That's just simply a response that the city does not have any responsive records in its possession. With respect to the first item, or it's the first request and there are several subparts, Mr. Moosen, as he pointed out, I think when he spoke, noted that he is seeking the names and titles of individuals. In response, the law department basically noted that the request is outside FOIL because the Committee on Open Government and the courts that have interpreted FOIL and FOIL itself make clear that FOIL is not a tool to be used by FOIL applicants to question city officials or cross-examine city officials. That's really, a lawsuit is the proper tool for that. Mr. Musin requested names and titles of individuals, so the law department took the position and cited to the guidance issued by the Committee on Open Government. And I think in his appeal, I just want to make this clear for the record, Mr. Musin had suggested that the link that I had put into the response, because I quoted the guidance published by the New York State Committee on Open Government, which, as the council knows, is the state agency that enforces FOIL. I quoted the guidance and I put a link to the guidance into the response itself. I think there was some claim or allegation that the link was broken and that was some sort of intentional vehicle by which the city attorney was attempting to obstruct his access to information. I want to make clear the link is not broken. As the city attorney for the city of Lackawanna, I have no ability or control over a state published link to an email resource. So I simply noted in response to Mr. Musin's request that the request is outside FOIL because FOIL is a request for records kept in whatever form that they may be kept in. Mr. Musin didn't ask for records, he asked for the names and titles of individuals. So it isn't even truly, from a legal sense, I don't believe a FOIL denial. It's stating that the information requested is outside the scope of FOIL, and that's the law department's position.
Thank you.
Yep. And I do want to make clear for the record that, the city denies any wrongdoing as it relates to any FOIL requests filed by Mr. Musin or any other conduct that Mr. Musin has alleged has been improper or in violation of the law.
Thank you. So this is gonna be in the court eventually?
No, this is not.
I'm not
She
talking to
stated
you.
it already, this is not in court. She stated
All right.
it.
He can't address us from the crowd, shout stuff.
Mr. Musin,
One more time, and you're gonna be out the door.
I think you were given your 3 minutes to speak, Mr. Musin. As I noted, the subject, the information that is in the packets that I'll note for the record, Mr. Musin presented to the council prior to the commencement of the meeting, which I believe Mr. Musin had intended to speak upon, relates to the issues that are before the court. This specific FOIL request is not before the court. In order to pursue relief before the court, Mr. Musin would need to exhaust the city's appellate process, which includes first going to the city council, because that is what the city code requires.
Take care. Thank you. What about all the other FOIL requests that you put in? Do we have to come here like 15 more times, or?
I can't speak to that, council member Sirdike. Mr. Musin has his statutory rights to appeal and the rights that are in the Lackawanna City Code. So that's within his province.
Okay. Anybody else have any questions? I don't want to say anything that would be contaminate the ongoing litigation.
Yeah, and I think for purposes of the FOIL appeal, what I explained is really the city's position, and it's just those 2 items that are included in this appeal.
Anybody, you don't have to go to that executive session or anything? I don't. No. Okay. Well, I'd like to make a motion to deny the appeal to the ongoing litigation and our council.
Motion. Second, I second.
Motion by Sirdike, second by Anderson to deny the appeal request based on ongoing litigation and council advice. Anderson?
Yes.
Moretti?
Yes.
Sirdike?
Yes.
Carried 3-0.
Motion to adjourn.
Second.
Motion by Sirdike, second by Anderson to adjourn meeting. Anderson?
Yes.
Moretti?
Yes.
Sirdike?
Yes.
Carried 3-0.